to do the presentation for our business and corporate law subject. My name is Yun Shi Shan.
I'm Thị Thảo Quang.
Hi, I'm Karen J. Bannon.
Hi, I'm Hedy.
And now we're gonna have the introduction for our case.
Today, we are going to discuss about the case of ASIC and David Hobbs. So, along with playing a very important role in managing companies. Along with playing a very important role in managing companies' performance, directors also have rights and have to carry out duties according to law. For example, in the Corporation Act 2001, it is indicated in the section 181 and 182 that directors and officers have to use powers and discharge duties in good faith to bring the best benefits to the company instead of abusing those powers for personal benefits. Penalties will be applied in respect of those who violate the laws. In order to clarify this, our presentation will discuss issues related to the case of ASIC and Hobbs. In this case, Mr. David Hobbs, a New Zealand citizen, and a number of individuals under his direction contributed to attracting Australian investors to raise funds of about 50 million Australian dollars, which are then invested in offshore funds of many other countries. Nevertheless, these investment funds were used for personal purposes rather than for the organization interests. Additionally, Mr. David Hobbs and his partner also faced civil penalty from Australia's Security and Investment Commission because of participating in financial activity without an Australian financial service license.
Okay, I'm going to tackle about the relevance of ASIC versus Hobbs, year 2012. And now the case confirmed the test of identifying a person as de facto in order to express them to liability for breaching director's duties. Essentially, it was established that the de facto director need not validly appointed since it can include a person not validly appointed who acts as director and his instructions are carried out in a manner that the decision clarified the meaning of acting in the position of a director. It was held that a person can be a director at any time, even without an appointment, if such a person had contemplated to some degree performing the roles of a director of a company. To this end, a person's role can over time or within a specified period of time evolve to that of a de facto. The court further held the titles are not determinants on whether or not a person is a director, but the substance of that individual's role. The impact of this decision is that once an individual has been identified as a de facto director of a company, he must act in accordance to the standard expected of a director, failure to which he or she will be in breach of the duties of a director and thus liable to civil penalty proceedings under the Corporation Act 2001. This case is significant in the development of corporate law in Australia, in that individuals may not act behind schemes of company by claiming that they are not the directors of the company in order to escape liability in instances where they have breached the duties of directors. Liability attaches even to the de facto directors. These factors were said to be the seriousness of the contravention and precisely the extent of the departure from the standards expected of a director and the actual and the possible effects of such contraventions, like mitigating factors such as the person contribution and factors drawn from the facts such as repetition of the breach. The impact of these factors is that the civil penalty imposed is determined by the aggregate of the separate contravention, so that the penalty imposed will be severe where a person has repeatedly contravened or committed multiple contraventions. In this case, Hobbs had committed several contraventions of the civil penalty provisions, and thus he was disqualified permanently from corporate management.
Between the company's interest and personal interest. Mr. Hobbs, FTC, and each of the corporate and scheme administrators breached Section 60185 of the Corporation Act due to the operation of the managed investment scheme was not registered. Investors were advised the following. The offshore investment of the funds were legal in Australia. Investors' funds were capital guaranteed, and the investors were at no risk of losing their money. Investors were promised of a 3% to 4% return on their investment per month on a regular basis. Investors' funds would be invested in A++ or A+ securities. The capital would be available on redemption after 12 months on a 60 days notice. The proceeds will be invested in United States Treasury strips or notes. However, these are false information. The court also identified Mr. Hobbs' act as a de facto director of FTC, PJCB, ISL, and Secured Bond, which breached both Section 181 of the Corporations Act, failure to exercise care and due diligence, and Section 181 of the Corporations Act, failure to act in good faith. Evidence supports that Mr. Hobbs had breached Section 182 of the Corporations Act because various company payments were made to Mr. Hobbs and others to provide them with a financial advantage, whilst causing financial damage to the corporations managed by Mr. Hobbs. This conflicts with Mr. Hobbs' interest as a fiduciary.
After considering of the definition director and officers in Corporation Law Act 2001,
the court concluded that a de facto or shadow director of the company include a person. This is also include a de facto or shadow director who making decisions that affect the whole company's business. The court followed the tests in Grandi v. Cheltenham Mining 2012, 200, and 296 in order to clarify what is meant by someone acting in the position of a director. Those got involved to: number one, a person may be a director even without any proposed appointment of the person to the position at any time. Second, it is quite possible for a role of person to evolve into one of de facto director over time. It is also possible that a person could act as de facto director for a limited period. In the ASIC solution case, a number of defendants were involved in the promotion of the schedule, and the responsibility for administrations was found to lie with the de facto directors, who were found to be in the branch of directors and officers' duty of care. The court also found the branch of Section 181 of the Corporation Act 2001, the branch of duty of the good faith, the Section 182, obtaining a benefit and the of operation, and a number of other branches related to misrepresentation, the law of ASIC lessening and unlawful promotion, and to the defendant's misconduct. The Section 769C has been involved by both ASIC and private in regarding to representations about future matters made by both companies and individuals. For the purpose of Section 769C of the Act, future matters have included states as to the type of investments in which funds would be placed, rates of refund on investments, courts has found that the range of contact fall within the direct definition of in relationship to a financial product or financial service.
Responsibility for any violation in various forms of penalty by laws. Thank you for listening.